Okay, so let's get this started. Good morning, everyone. My name is Andrea. I work here at Jurado and Associates with attorney Romy Jurado. I just graduated from Florida International University from an LLM. I am an attorney in Venezuela. I just passed the bar and I'm waiting for my license, actually, to also practice law here in the United States. I've been doing trademarks with Romy since 2019, I believe. And today we will be talking a bit more about what a trademark is and everything that you pretty much need to know about trademark prosecution, okay? So, as I said, this is Trademarks 101, what you need to know about trademark prosecution. Well, this is the presentation outline. We will talk about types of trademarks, benefits of trademark registration, selection of trademarks, requirements for registration, dealing with the examiners, and registration with US Customs, okay? Before we start, I just wanted to say that trademarks, patents, copyrights, and trade secrets are all considered intellectual property. That is basically of the human mind. You need to, I always tell my clients to contrast this with land, buildings, which are considered like real property, you know, like this is intellectual. All of this comes from your mind. Pretty much patents are protected inventions, copyrights protect original, artistic, or literary creations. Trade secrets protect information that has value because it's not generally known. Just you need to think about the formula for the Coca-Cola. That's the typical one. But today we're not talking about any of those. We're just talking about trademarks, okay? Give me one moment. I believe I have a question. Yes, Chanda, I will start moving the slides when I start the presentation. Don't worry about that. And I just wanted to say, guys, please go ahead and put your questions in the chat, in the Q&A. I will try to answer as I go. And if not, we'll have a Q&A session at the end, okay? Okay, so are you going to provide the slide handout? Yes, we are going to provide our presentation in an email in the end of the session, okay? Don't worry about that. Okay. So as I was saying, today it's merely about trademarks. Let's get started. So what is a trademark? Basically, a trademark indicates a source of goods or products, okay? Before, there was a difference between trademarks and service marks, being the trademarks indicating a source of goods or products and the service marks indicating a source of services. But nowadays, I will just refer to both as trademark because in the real world, there's no such difference. We just call all of those trademarks, and you will see in the presentation that sometimes it's referred as to service marks. It's the same. It's just products or goods versus services. So as I was saying, trademarks are typically of are a type of intellectual property. As I said at the beginning, the property itself is intangible, but, and this is important, it still can be bought, sold, inherited, traded, and protected, and that's why we are here today. So that's the difference. Service marks, it's just pretty much services, but as I mentioned, it will be refer as to marks or trademarks, okay? So trademark do, basically. A trademark identifies the source of goods and services, as I said. It distinguishes them from the goods and services of another party. And basically, it provides legal protection for a brand. That is the main goal of a trademark. Okay, so I just want to say what a trademark does not do, because I think it's important as well to understand what a trademark doesn't do. And a trademark doesn't mean you legally own a word or a phrase. It does not give you exclusive rights to the word or phrase in general. Okay, so that it's important. It only gives you exclusive rights to the word or phrase when you are using it as a brand for your particular goods or services. And this will come handy in the future when we start talking about the difference about this. It doesn't mean that you can stop other people from using the word or a phrase, unfortunately. Like you can try, and we will talk about this, but if someone wants to use it, the only way that we can stop someone from using it is pretty much a lawsuit. And it does not mean you owe, anyone owes you money. We can, of course, have agreements with someone that can, saying that they can use and they need to pay you royalties, but we'll discuss that in the future. Okay, so basically marks need to be distinctive, okay? Clients always ask if they need to use their business name as their trademark, and the answer is basically no. You can, but you don't have to. You could instead develop like a very creative trademark to help customers identify your marketplace. So as you are seeing in the presentation, the trademark law only protects distinctive marks, okay? So when a word is arbitrary, fanciful, suggestive, it's deemed inherently distinctive. This is good. This is what we want about trademarks, to be invented words, fanciful. That's what we want. What we don't want is descriptive, geographic, or generic terms. And you will tell me, Andrea, wait, but I know like Apple, that's one of the biggest marks in the history, and that is a very generic name. True, but it's Apple in connection with a computer, not Apple in connection with the fruit. And that is a huge, huge, huge difference, as we will see. Oh, I see I have questions. Wait for me a minute. Yes, you will get a copy. Thank you, Jamie, for congratulating me. Okay, awesome. Okay, I will just go back a bit so you can see what I was talking about. Basically, I was saying that the difference between trademarks, service marks, we already spoke about that, and that the trademarks must be distinctive, and we are now hearing the distinctiveness. We didn't miss much of the slides. I'm so sorry about that. I thought I was sharing the right screen. I'm sorry about that. Okay, so as I was saying, arbitrary words. There's a great example, as I mentioned, Apple for computers. That's very arbitrary. Apples have nothing to do with computers. Apples are a fruit, so that is arbitrary. I just chose a name and applied it to another, a completely different thing. That is what we want in trademarks. Suggestive, suggests some quality or character associated with the goods, but not so explicitly that no imagination is needed. Coppertone for sunblock. We all know, like we all refer to Coppertone when we refer us to sunblock. That's good. Fanciful. It's composed of coined words. What are coined words? Things that don't exist before you invented the mark. For example, Xerox. That is not a word. That doesn't mean anything in any language. Okay. Well, you can see there, descriptive, mark that descriptive. Beef and brew for a restaurant. You can get beef and brews in a restaurant. What we don't know, when we don't want generic words. We don't want apple for a fruit, okay? We don't want computer for a computer. We don't want a podcast for a podcast. That will never get registered, okay? Let's keep going here. Okay, this is important. What are the benefits of registering a trademark? Okay, so basically trademark rights can be created in two ways: common law registration. Registration, it's not required. You don't have to register a trademark with the USPTO. However, it is your choice in the end as a business owner or to register a mark or not, but we do recommend it, and here's why. In the US, the first user will always have superior rights under common law. So when you first start using a mark in connection with some goods, some services, you will have superior rights. Even over other registrations, that will always be the case. However, having a registered mark will come handy when providing proof of who used it first. That is why we always recommend to register your mark, because it's the greatest source of proof when you need to, imagine you're in a lawsuit because you started using your brand and someone else starts using that after and gets more followers on Instagram. I don't know. So you sue them. How can you prove you started using this first? Having a registration with the USPTO is the best way to prove that, okay? So that is basically it. That's why we basically recommend registration always. It's a great, it's the best proof that you can get. It's the greatest presumption that you actually own what you say you're the owner of. And it gives you coverage in the 50 states of the United States and its territory, so it's great. There's a difference when using the little symbols that you see next to the marks, the TM and the R circle. There's a difference. So, and neither of them require ever. You can have a registered trademark and you don't have to use it. You can use it if you feel comfortable with, but you are not required to. It does put the public on notice that the ownership rights are being claimed when you use it, but you don't have to. And basically the TM, you can use it whenever you are in the process of having the registered certificate with the USPTO, and the R, you can use it only when you get the mark registered. You cannot use it before that. So for example, you told me, well, Andrea, but I already have the process going on with the USPTO. Can I use it now? No, absolutely not. You cannot use it until I give you your certificate of registration, okay? That it's like the most important thing to understand about the R and the TM symbols. Excuse me. Okay, so as I was explaining, federal registration rights are created when the trademark registers with the USPTO, not before. And it gives the legal presumption that you own the mark and you have right to use it in all 50 states of the United States and the US territories. That's great because this is federal law. So it doesn't matter if you are only using it now in Florida, we can get the registration going on with the USPTO. And once you get the mark registered, you are able to use it all across the United States. That's very handy. So a federal registration through the USPTO does not give any presumptions related to the use or ownership in other countries. That's very important to understand. It's just the US, okay? Registrations in other countries arise only through the trademark office of that specific country. We can, however, use the registration that you have in the United States and apply it to the other state through something that is called the Madrid Protocol. But until you do that, you can only use that in the United States. There are two different processes, okay? Let's keep going the presentation. Okay. I will get back to this because this comes when you already apply for the mark and there's an infringement. And I don't know actually why this is here. I need to explain first how to apply to a mark to be able to understand why the USPTO can ever like say they won't register a mark. So we will come back to the DuPont factors. Okay, So, selection of a trademark. You will come to me and you will say, Andrea, this is my mark. I want it registered with the USPTO. What's the process now? And I will tell you. We do like a preliminary search of the mark in the USPTO system. Okay, so we use whatever you give us and search it in their system. It can be, I don't know, the realtors are the best, or Andrea's purchases for purchases. We will do our research and tell you, listen, we do think this is going to register, or you might want to add some words or delete some words or whatever. But that's the first step. We do a search in the trademark register, in the registry, to see if there are another similar trademarks that might conflict in the future, okay? There's no way that I can tell you this will be registered 100% sure. The only person that can tell you is the attorney from the USPTO, and unfortunately, we don't have access to the attorney of the USPTO until we submit the application with the USPTO. However, I can tell you, I think based on my knowledge and whatever I search in the USPTO registry, that your mark will be registered. I can say that, but no one can tell you it will be 100% sure, okay? Well, after we perform the full search, oh, wait, I don't know why this is in this order. Okay, so that's what I wanted to say. There are two main pathways to register a mark. The first one is when you're actually using the mark in commerce in connection with the goods, the products, their services, whatever you are branding you. So you will tell me, Andrea, I already have this mark. I've been using it for X amount of years now, and these are my websites, these are my social media, or this is my physical store, maybe. I don't know what you do. And we can just go ahead and submit proof to the USPTO that you are actually using this mark. That's great. That's the first basis. It's called A1A basis. And basically the USPTO examining attorney just gets it, reviews it, and tells us if there's a problem or not. What's the other pathway that it's the most common amongst my clients? Because as I say always, it wins you a bit of time. It's intent of use. We use this when you are not actually using the mark in connection with commerce, but you do have a good faith intention of using this in the near future. So you tell me, I'm in the process of getting this produced, this, I don't know, this water bottles. I'm getting them produced and I will start selling them very soon. And I will tell you, okay, let's do intent of use. This wins us time because the USPTO is currently getting about 8 months to assign an examining attorney to each application. So in these 8 months, you already have a case with the USPTO. We already have an application with them. And whenever they come back to us, those 8 months later and tell us, okay, so all's good. The only thing that we're missing is proof. You had already had these 8 months to produce proof, and we will just send it and they will just be in their merry way. So this is a great way for people that are in the process, but they're not quite yet. So intent of use, very, very handy. It's like, I would say 80% of our clients do it this way. It's great. What you need to keep in mind when you do intent of use is the USPTO will never register a mark that they don't receive proof that it's being used in connection with commerce. So yes, we can start the process, even though you're not selling, you're not providing services, but you will never get the certificate, the registration certificate, until they receive proof that you are actually using the mark in connection with commerce, okay? That's very, very, very important to understand. As I told you, either way, you will get an examining attorney that will examine your mark. And it will basically be two answers. One, it complies, it would get published for a position that is in like a internal like paper that they publish saying these are the trademarks that are trying to be registered. If someone makes an opposition, they will just investigate it. And then your trademark will be registered pretty much. Or the examining attorney can come back to us saying that there is likelihood of confusion with another mark. And here is where the DuPont factors that I mentioned earlier come handy. So let's get back to those. All righty. So the DuPont, this is like the landmark case in trademarks. This is where basically all the trademark examiners, officers go to identify if a potential trademark will conflict with another one. There are 13 DuPont factors. And basically, what this means is the concept is to avoid confusing customers about the source of goods or services. So if two marks, according to examining attorney, are too similar that the public will be likely, will have a likelihood of confusion, they will issue what it's called an office action. Okay, so what the test that USPTO uses is 1, are the trademarks confusingly similar? And 2, are the goods and services related? Because once again, we can have Apple for computers and Apple for, I don't know, clothing. And those two, even though it's the same name, the goods are not related. So it might get registered, right? Apple is a bad example because Apple is so known that probably you won't get the registration for that one, but I just want you to understand the difference. It's 1, the trademarks are confusingly similar, same names or very identical names. Let's see, McDonald's and McDoubles. Those are similar, but the second is, are the goods or services related? So if you have McDoubles for makeup, it's not a restaurant, even though the name is similar, it might get registered. Okay, so the examining attorney basically will issue a refusal if the trademark in the application is confusingly similar with an already registered trademark, and the goods and services in both of the applications are related. So they use what it's called the DuPont factors, to weigh the two marks and determine if they are confusingly similar. As I told you, there are 13 of them. There are some that are more weight than others. So for example, one of the most important ones is the first one that you see there, the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. This is like the one that they love to use. So for example, I had one client that wanted to register a mark called Sus Juice for proteins. And that was amazing. I was like, yeah, this is a very good name. And the examining attorney came with likelihood of confusion for the similarity of a previously registered mark, that the name was, no, exactly. Sus Juice was the previous mark and Prosta Sus was my client's. So we just argued to the examining attorney, listen, these are not the same goods, they are not related, and basically no one that wants to go for one product will be confused with the other products. And that's pretty much how you do it. It takes time to argue with the examining attorneys, but they're willing to listen to your arguments. That's a good thing about trademarks. Well, and you will see whenever we send this, what are the 13 DuPont factors that they weigh in, but it's basically this. And this just comes when they think there's likelihood of confusion. It doesn't happen in every case. You can just get your trademark published for registration without any problem from the examining attorney. Okay, let's get back to where we were. Okay, so this is what I was telling you. So they issue an office action saying, listen, this is too similar. And basically at this point, we have two options. We can respond saying, arguing why it's not similar, or we can just let the mark die if you are not interested anymore. I would hate to see that, but you do need to know that there's an option. You basically get 6 months to respond to the office action. And if it's successful, your trademark will be, once again, in its merit pathway to registration. It will be published for a position, and then you will get the certificate. If the attorney comes back and say, I don't buy your argument, we can always file an appeal. That's another process. It's more complicated, but I can say that 90% of the trademarks that we have done here, we have never had to do an appeal. Only one, I think, since 2019 that I've been working here, we have had to do an appeal for a trademark. So it's not that common. Once again, I'm sorry, it gets published. You can see there, it gets published in the official gazette for 30 days. If it gets opposed, the trademark examiner will review it again. If not, it will just get published. You will get your trademark, your certificate, and it's very, very good. When you used intent of use, this is where we send the proof if we haven't sent it yet. But if we apply using the proof, like that's pretty much it. You get a notice of allowance, that's it. Okay, what happens now? Now you get your certificate. I tell you, there you go. You can use your R symbol next to your trademark. Everything's fine. We are all happy. So 5 years have passed since your application was submitted. You get your registration and everything's good. We need to file a renewal. Between the year number 5 and the year number 6, a renewal needs to be submitted. The renewal basically says, hi, USPTO, it's me again, and I'm still using my mark in connection with these products, services, or goods. And we need to prove again that you are indeed using this in commerce, in connection with whatever you are trying to register. You had registered, okay? It's a simple process. It's important because if you don't do it, your trademark will die. And all the effort that we spent 5 or 6 years ago will be lost, and you will have to start the process again. There's no way if this 6 year passes, they give you like 6 months after that, if you pay a fee, whatever, but if that time passes, we will there's no way to revive that mark, and we'll have to start all over again. We don't want to do that. So we always calendar this. We will let you guys know when it's time to submit the renewal, and you will be good. After we submit this renewal, there's another renewal. I know, right? Every 10 years, you need to renew your mark. You need to say, once again, that you are using your mark in connection with commerce, and that's it. Submit proof every 10 years, and you can do it eternally, as long as we submit proof every 10 years. Yeah, well, this is how to deal with trademark examiners. I don't think you need to worry about this because I will be the one dealing with the trademark examiners. But as I told you, they're very willing to listen to our arguments. They're always available on the phone. They're always available via email, with the USPTO portal. Like I love dealing with examiners, attorneys. Like that's why I do trademarks, because I think they're it's one of the areas of law that they're willing to listen to you. So I like it. You don't have to worry about that. That's my job. Well, as I said, this is also my job, responding to the office actions for a likelihood of confusion we just try to argue these 5 things: that the customers are sophisticated. I already explained. Both, they won't get confused between one and the other mark. The goods and services are unrelated. There are different trade channels. One, it's all via website, and the other so physically. That's my job. Okay, this is like the last part that our client, we always want to advise our clients to do this, especially if they are importing goods. So the registration with US Customs. Recordation with the US Customs and Border Protection, it's a critical step in helping to stop products from coming to the United States, basically. So without a recorded registration certification, US CBP is powerless to stop the importation of even the most obvious counterfeit goods. So I would say, if your mark is a service mark, this step you don't have to worry much about. But if you are bringing goods from abroad, you're importing goods, and your mark is based on importation, this is critical. We need to register this with CBP, because otherwise, as I explained, they're powerless. Even though they see something called Nikes instead of Nike, they cannot do anything if they don't have your trademark certificate registered with them. So this is like the last step, and we always recommend this to our clients. This is how you can register with customs with CBP. It's basically very easy. You just have to follow that website. You can hire us to do it, of course, but if you can do it yourself, you can. You don't need an attorney for this. And this is pretty much what you need. Once again, we'll send you the presentation, and you will have it in writing. Well, there are other practical matters with CBP registration. Once again, it's very straightforward. You can just go ahead and read it whenever we send it to you, okay? Okay, so thank you for attending the presentation. This is how to contact us. Now I will be answering the questions. I see that I have plenty here. Give me one moment so I can get started with this, okay? It's almost lost its name when a judge turned to his assistant and said, "Go Xerox this." Yes, that's correct. So correct. That happened to Xerox, and that also happened to Velcro. That's also funny because Velcro, the fabric that just does this, it's the brand's name. It's not like that fabric. That's called another thing. But the brand got so famous that they actually had to do a campaign to make customers stop calling the fabric Velcro, because once something so related with a brand, it can lose the protection of the USPTO. So actually Velcro had this very hilarious yeah, like it was a commercial or something saying to their customers, stop calling this Velcro. It's not Velcro. Velcro is just the brand. That's funny. Yeah, that has happened throughout the years. You can lose your protection. So yes, you want to be known, but maybe you don't want to be too known. Let's see, just make sure you can prove your date. Okay, so first date does not have cross state line. No. So okay, so Stan is asking, so first date does not have to cross state lines. It does not. You can use you can start using your mark. Let's say here in Florida, we can get it registered, and then you have protection all over the 50 states and the territories. So the answer for that question is no. Let's see If we are using a mark for decades and prior to someone else trademarking a similar mark, is it possible that they can make you stop? Because Joseph, I don't want to answer this without knowing what's the real situation, but what can I tell you is potentially, yes, potentially. We need to do further investigations in order to just check what's actually, and guys, like, once again, there's always a way to argue, and like we just need to see what are the best arguments for our clients. Let's see, auto manufacturers register names before they start selling the car, or am I wrong? Or do they make the car and the badge and put it on the car and then sell it and hope the name is not taken? Stan, as I told you, I don't know how auto manufacturers work because I have never represented one, but what they are probably doing is intent of use. So what they do is record, submit the application with the USPTO as intent to use. They start selling the cars, and then they provide the proof to the USPTO. But the USPTO will never register without proof. That is what I can tell you. Different classes unless the name is so widely known that it transcends all categories, like Coke. Is that correct? That's correct. Yes. Jimmy, does the registration with US Custom will work for export process? I don't know if I understand correctly. What it does is it prevents counterfeits from being ingress to the United States. You will have to know the law of the place that you are exporting your goods. So if they have something like our CBP, you need to check with them. What would be the cost to register a trademark? Oh, okay. So fees are $1,300 per mark. And that includes the preliminary search that I told you about and filing for the register mark. What it does not include is the fee that you need to pay to the USPTO. The USPTO charges a fee of $350 per class. And I told you already, the class is the description of goods or services. So whenever we do our investigation, I will tell you, you will send me a list of all the products or services that you provide, and I will let you know how many classes you need to be registered in. Okay, that's how it basically works. For example, shoes and clothing are all in the same class, so that will be one fee. It's international class 25. No one cares about that. But however, makeup and makeup brushes are two separate classes. So if you have a makeup brand, you want to register also brushes, it will be two different fees. It will be $350 for the makeup and $350 for the brushes. That's how it works, and that's not included. You pay it directly to the USPTO. How much is your service? Okay. Okay, Robert, let's see. When a real estate agent or agency pays a photographer to take photos of their home listing, isn't it true that the real estate agent or agency usually gets a license to use those photos, which will include distributing? Yes, so as I told you, that's a licensing agreement. You can get licensing agreements potentially with anyone that owns a trademark. So if you go to Coca-Cola right now and say, Coca-Cola, I would like to sell Coca-Cola in my store, you will get a licensing agreement from them and they will get royalties. That's pretty much how it works. But yes, Robert. FedEx used to run ads and it says, stop calling us FedEx, our name is Federal Express. And yeah, like it's the same as Velcro. Like this has happened plenty of times. Like brands get so known across the globe for what they do that they can lose protection. It is what it is. Madeline, a copyright protects an original artistic or literary creation. So it's a bit different. We do also copyrights, but it's a whole other thing. It's also done through the USPTO, but it's very different from trademarks. I'm more than happy to advise to you on that. You can contact me after the presentation. Fran, I cannot address basics of copyright because this is a trademark presentation, but please go ahead and contact me and I will be more than happy to provide more information about that. Caleb says, regarding the use of photos, when I spoke to the MLS compliance specialist, he said that by the listing agent clicking yes on any broker advertised, they are allowing me to use the photos on my social media. I also received written permission from the listing agent to use the photos. Is there anything else you would recommend me to do in order to avoid litigation? Okay, Caleb, you can contact me directly because I cannot advise you without reading whatever agreements you have in place, okay? So just please go ahead and we will be more than happy to help you. Hi, Andrea, how is this related to real estate? Could you give someone examples? Yes, absolutely. So you can actually advise, basically for me, it goes two ways. This is related with your mark as a realtor, as a broker, as a real estate agent. You can protect yourself from other, let's say your mark is Demi Sahinkaya. I'm sorry if I'm pronouncing that wrong. So, and you are a very famous real estate agent in South Florida. You want to prevent other real estate agents from using your name to sell houses, correct? So this is where it comes handy. You can register your name. You can be the owner of your name in connection with real estate services. That is how you can protect yourself. And the other way, if you have a client, I don't know, we do plenty of business closings here in the office. So we have business brokers that work with us, and maybe their clients want protections for their businesses. So that's another way that this is related to real estate. You sell a business to someone and you can tell them, listen, maybe you want to get your name protected so no other people can start doing business under your name. That's another way to do it. Robert, this is becoming a big issue with a few photographers who took and are paid photos for it. Okay, Robert, yeah, I understand that. Please contact me and I will be more than happy to help you. Fran, is it correct that if you post a photo and put the C, it is yours? No, that is not correct. You need to get a copyright. Your copyright needs to be registered with the USPTO. Like, it's like if I like Jurado and Associates, that's not registered yet, so I cannot go ahead and put an R next to it because it's not registered with the USPTO. It's the same thing. You can only put that little C next to it when you have a copyright registered with the USPTO. Do you have any comments for real estate agents? Yeah, I already, Michaela, I already said that, but I will be more than happy to repeat it. You can protect yourself from other people wanting to sell real estate under your name. That's the one that it jumps to my mind immediately. I'll be more than happy to explore other options that can protect real estate agents. Absolutely. Sam, if I want to import shower faucets and call this brand, for example, Tiffany or Tiffany faucets and showers, will be this considered okay? It is not the same on Tiffany diamonds. Once again, potentially, yes, but maybe there's a registered. So we need to, that's why we need to do the investigation first in order to let our clients know if it's okay or if it's not okay, because they're different services or goods, but maybe there's another Tiffany faucets. We don't know yet until we do the investigation. I think these are all the, no, we have more, wait. Can we have a replay of this training afterwards? I do think this will be available, the recording and the presentations. So if it is, you will all receive one. Okay, I think this is all of the questions that I had. Thank you for being with me for this presentation, and please go ahead and contact us if you have any questions. You can see our website, our phone number, my personal email, and we will be more than happy to help you. Thank you so much again, and have a wonderful Thanksgiving. Bye.